Call this meeting to order. Bonsoir et bienvenue à la réunion du comité mixte spécial sur l'aide médicale à mourir. Je souhaite la bienvenue aux membres du comité.
Welcome to the Special Joint Committee on Medical Assistance in Dying. I would like to begin by welcoming members of the committee, witnesses, as well as those watching this meeting on the web. My name is Marc Garneau, and I am the House of Commons' Joint Chair. I am joined by the Honourable Iona Martin, the Senate Joint Chair of this committee.
Continuing our examination of the statutory review of the provisions of the Criminal Code relating to medical assistance in dying and their application. I'd like to remind members and witnesses to keep their microphones muted unless recognized by name by one of the joint chairs. A reminder that all comments should be addressed through the joint chairs. When speaking, please speak slowly and clearly. Interpretation in this video conference will work like an in-person committee meeting. You have the choice at the bottom of your screen of either floor, English, or French. With that, I would like to welcome our witness for panel one, who is here to discuss MAID when a mental disorder is the sole underlying medical condition. So welcome to Professor Jennifer Chandler, who is a professor of law at the University of Ottawa. Thank you for joining us. We'll begin with your opening remarks, Professor Chandler. You will have 5 minutes, and that will be followed by a question period. So over to you, Professor Chandler.
Thank you. Can I confirm you hear me? It's okay?
Yes, we can.
First, thank you very much to the committee for having me here today. It's an honor to address you, and I hope that the remarks I can contribute will be helpful to you in your consideration of a difficult issue. As Senator Garneau mentioned, my name is Jennifer Chandler. I'm a professor of law, a full professor of law at the University of Ottawa, where I teach health law and specialize in mental health law, neuroethics, issues around brain interventions and the law. I am speaking as an individual, of course, and don't represent the university nor the expert advisory panel, of which I was a member, nor do I represent the views of the CCA panel before that, of which I was also a member. I was thinking to myself, what could I say that would be of use to this group in these opening remarks in light of what other witnesses have brought to you, done an excellent job bringing to you before me. And I thought perhaps, given that I'm a lawyer, I would speak from a legal perspective and talk about this question of discrimination, because this is invoked as a central issue in trying to decide what to do about eligibility of people with a SUMC, sole underlying medical condition, being mental disorder. So at the moment, the law excludes, as you know, a particular category of people from eligibility, namely those suffering solely from mental disorder. And this exclusion is defined on the basis of a specific class of disability. There's two arguments out there which you have heard about how this is or is not discriminatory. One view holds that excluding a group of people is discriminatory when done on a basis of mental disability because it withholds from them a benefit or an option that's available to others, and this is unjustified when they meet all the other eligibility criteria that others meet. Another view holds that offering medical assistance in dying to people with disabilities, including mental disabilities, is discriminatory because it exposes them, and only them, people with disabilities, to an increased risk of death by suggesting perhaps that death might be a good option in their circumstances and or by making it easier for them to access death. In other words, then, to summarize, in one case we have access to an option that's viewed as a benefit, which is unfairly withheld, and on the other hand, access to an option which is a harm, which is unfairly imposed. So how does one reconcile these views? I think one can be confident that people holding both of these views hold them in good faith and strongly believe in the justice of the view they're espousing with respect to discrimination. And in fact, as you've heard, I was watching the proceedings from Friday, you've heard also that people with lived experience both hold these views as well, these opposing views. So I propose to offer a few thoughts from a legal perspective on how these opposing views of what's discriminatory and what is just or unjust in these circumstances can be reconciled. Evidently, my view is a legal one and should be tempered with the insights of those with lived experience and those who provide care, and in recognition that others might differ with my reading of the cases and my interpretation of the law. So essentially, the Supreme Court of Canada has had to address this particular problem on multiple occasions in the past of whether differential treatment of a group with a disability is discriminatory or not. And in those cases, it has noticed or noted the challenge of what it came to call the difference dilemma. In essence, what this alludes to is that in some cases, to achieve equality, to promote dignity, it's necessary to treat people differently, whereas in others, it's necessary to treat them in the same way. And to give you a concrete example from a case involving segregated schooling for children with severe physical disabilities, the court said a separate or segregated stream of schooling could protect equality or violate equality, depending upon the needs, capacities, and circumstances of the particular child in question. So this difference dilemma means it's very hard to point to exact same treatment or differential treatment to really get at this question of what best promotes equality. So how then do we figure it out? And if you look at the range of questions that has come to the Supreme Court posing this particular type of problem in a range of cases, whether it's schooling, whether it's access to particular workers' compensation benefits for physical versus mental injuries, my reading is that the court is quite uncomfortable with blanket attributions of a specific set of needs, capacities, and circumstances to a group as a whole, and is very much more likely to be comfortable with a regime, if it is possible to do so, that provides for individualized assessments to verify that any presumptions are in fact accurate in individual cases. So we come to the blanket exclusion of all people with mental disorders. This would seem to be a problem. This is a very heterogeneous group of people with very different needs, capacities, and circumstances. And the question, I think, for you is, do the criteria in the code, the criminal code, along with perhaps recommended measures that the expert advisory panel put in place, offer an adequate framework to do this kind of individualized assessment safely? I think so. I was a member of that expert advisory panel. So of course I would think that we had put something forward that could work. With certain caveats that I'd like to draw to your attention, I think that this question of adequate funding is a key safeguard. And it's not just, it's an adequate funding question in two directions. So adequate funding of the social supports are a key to ensure that those who can be supported, whose suffering can be alleviated, will have the opportunity to have it alleviated. And a good and compassionate society will try to do its best to help those who are struggling. At the same time, we have to note that there are situations in which just about any social supports will not be sufficient to alleviate intolerable suffering. In a second way, adequate funding pertains to the kind of funding that's available to assessors and the infrastructure made available for assessors to do a careful and thorough assessment. The kind of thorough multidisciplinary assessment required here involves a long process and multiple people involved in coordinating a range of potential supports. This will take time and resources to do properly. And if those funds are not available, I see a twin risk, one that people will withdraw from providing assessments to people who are suffering intolerably because they won't feel that they can do it properly, or conversely, some might do a rushed assessment with risk in the other direction. So I think that the kinds of things we put forward in our report with respect to the infrastructure are quite important to consider and to put in place within the realm of what's reasonable and possible. And the other safeguard...
Sorry, Professor, if you could wrap it up, please, so we can get to the questions.
Certainly. I was just going to say the other safeguard that I think is critical is the detailed collection of information, and I understand that the reporting regulations are being amended to come into force this January with the addition of a range of other details, which I think will be exceptionally important in having the actual data about what's happening, as opposed to guessing about what might be happening. Thank you.
Thank you, Professor. I'll now turn it over to my co-chair, Senator Martin.
Yes, thank you. to my co-chair. We'll go into the first round of questions with MPs. And for the first 5 minutes, I have Mr. Barrett starting us off.
Thanks, Madam Co-Chair. Good afternoon, ma'am. Thank you very much for joining us. So we have limited time, so and I'd like to get through a couple questions with you if I could, and so I'm going to read them so I'm succinct as well. The first is that it appears in my reading of the expert panel report that there's a contradiction that I'd like for you to help me resolve. And I'll paraphrase, but it says that the current legal framework can apply to MAID where mental disorder is the sole underlying medical condition with no new legislation or additional safeguards. But it also says that irremediability in the case of MDS-UMC is difficult, if not impossible, to predict. And the report fails to offer evidence that it is possible or provide specific guidelines on how to determine it. So in order for a person to be eligible for MAID, irremediability must be determined. So how do we reconcile this challenge? Because it seems to me that without clearly defined roadmap to determining that a person's mental disorder is irremediable, it would seem that MAID with mental disorder as the sole underlying medical condition is not compatible with the existing law.
Yeah. So I think I'd say two things. One, just a point of clarification that the term irremediable is not a medical or scientific term. It's a legal term that's been put into a piece of legislation and, in fact, is defined in the law in terms of incurability and so forth, the three subparts. But together, I think the question you raise is a good one. Like to what degree of certainty do we have to have with respect to the future in order to satisfy that criterion? And I think it's going to be impossible to have absolute certainty, obviously. It's also going to be impossible to be certain in any individual case if one were to gather group data that on average a specific set of characteristics is certain percentage of likelihood to be incurable or not. It will be hard from that average group to be certain that it applies to any one individual. So I think it's clear that 100% certainty cannot be what's meant by the legislation, nor achievable in any case. So we're left with the question of how much certainty and on what basis of what type of evidence do we think we have met these legal criteria of incurability, unalleviatability, and so forth.
And I appreciate that, and thank you for that succinct answer with a pretty broad question. It's important to note that in the final report, it does say that the evolution of an individual's mental disorder cannot be predicted, as it can for certain types of cancers, as an example. So I think that that is certainly a challenge. My next question is with respect to media reports, and I'm not sure if you're familiar, but this summer there were CBC reports about a woman from Ottawa who had applied for MAID 3 times, 2 times before the passage of C7, and then 1 time since the eligibility was expanded. And so she was denied, this individual was denied each time, but then was connected to a MAID assessor in Toronto, and she was approved for MAID. Does that concern you that different MAID assessors are coming to different conclusions with respect to what conditions are acceptable for MAID, and kind of that shopping around for a provider who's going to or an assessor who's going to give them the answer they're looking for instead of the one that's based on the intent of the law?
I'm afraid I don't know the details of the case you're referring to, so I'm not sure I can give a perfectly tailored answer. I would, in order to answer that question, I would want to go and look at what might have changed between those assessments to determine if there was any justification for a different result. If nothing had changed, then that would be perhaps one, we should look at that in one way. If there had been new evidence that had come to light, that would also be relevant. I think that one of the recommendations that we made was that collateral information, the existence of prior requests, should be accessible to subsequent assessors to inform them and to also shed light on repeated assessments so that this could be determined, evaluated.
I think that's just about it for my first round. Thanks
Okay.
very much, ma'am.
Next, we will have Mr. Maloney for 5 minutes.
Thanks, Madam Co-Chair. Professor Chandler, thank you for joining us this evening. I'm going to ask questions very similar to what Mr. Barrett just put to you. You talk about discrimination. If you exclude somebody solely on the basis of their condition, that is discrimination. The issue is whether or not that discrimination is justified. And I will put this to you as a statement, and you can tell me whether you disagree or not, but if the basis for the discrimination of not including people with mental disorders is that the risk is high enough that the process could be wrong, that would be a justified basis for excluding them, perhaps. Is that a fair comment?
I think so, except I would have trouble with saying that solely about mental disorder. And the reason for that is that people with mental disorders are already included if they have a physical disability, for example. And so it's hard to regard it as the risk of error to be unreasonably elevated in one context and not in the other. We'd have to explain that difference.
Right. I was going to get to that in a moment, so I'll go there now. I mean, if a patient has terminal cancer, but they also have a mental disorder, they're applying for, as the law currently stands, and as it did under C-14 and C-7, if the person could qualify for MAID solely on the basis of the cancer diagnosis, but if they are not excluded from having access because they also have a mental disorder, that's the state of the law, correct?
Yes.
Okay. So the question in that scenario becomes whether or not the mental condition is driving them to make that decision more so than it would perhaps if they didn't have a mental condition. Is that fair?
To my knowledge, the courts have said that assessment of suffering has to be made on the basis of the totality of the circumstances and is not to be tied to one particular condition that the person might have.
Well, as the law stands, the one condition being a mental disorder, they wouldn't qualify at all. So I'm saying, as the law stands now, it's not a barrier as opposed to giving them access to the process. So let me go back. You referred to some examples of Supreme Court of Canada cases where the Supreme Court dealt with discrimination in situations dealing with schools or receiving benefits. That's markedly different than terminating one's life, I would say. So I'm not sure that those cases are it's not apples and apples, if I can put it that way. So we get into the situation where, and you said, irremediable is a legal term, not a medical term. What we're talking about is whether a mental disorder is permanent and cannot be cured, which would allow a person to qualify for MAID. That's at the heart of what we're talking about. And in order to do that, you need to have certain protections built into the system. So you need to be confident that doctors assessing somebody with a mental disorder is as capable of making that assessment as doctors who are dealing with somebody who has cancer, to use the example I referred to earlier. Are you confident, based on your experience through the panel process and whatnot, there are safeguards in place enough that it should be that it will work with people solely with mental disorders?
Yes, I think I am. And I want to step back to just say that I think we shouldn't perhaps be comparing the cases of SOL, SUMC, with the cancer cases. We should perhaps be comparing the Track 2 type cases of physical disability with Track 2 type cases of sole underlying condition being a mental disorder. In both those cases, there's uncertainties, often uncertainties about whether a person will come to have suffering that's alleviated with the prognosis and so forth. So to me, the question would be, can we separate out the treatment of mental disorder and leave in place the physical disability cases on Track 2 is one point to justify. The other thing I would say in response, if we stay with the comparison of the cancer cases and the solely mental disorder cases, is that we already have cases where people with a mental disorder, as you point out, have a cancer and are seeking MAID, and we have to assess capacity in that context. And so one presumes that one can assess capacity across both types. And doctors have experience in assessing capacity in solely mental disorder cases, such as of other high-stakes decisions of refusing.
I'm running out of time, but
Yeah.
the difference is there when there's another medical condition. You're assessing capacity. If it's solely the medical disorder, you're not just assessing capacity. You're assessing the permanent nature of the condition. So it's a little bit different. Is that
Okay,
fair?
thank you, Mr. Maloney. Yeah. Okay, thank you very much. Next, we'll go to Monsieur Thériault for 5 minutes.
Merci.
Thank you, Madam Vice Chair, and welcome, Dr. Chandler, Ms. Chandler. Regarding what you've presented about principles affecting discrimination, I do follow that, and I understand you. You have participated in drawing up the experts' report. Am I wrong to say that the recommendations were intended to address the how-to, if we're not questioning eligibility, in the how-to, how to go about it to ensure that all this remain morally and ethically acceptable? So basically, these are guidelines that were being proposed. Am I wrong on that? Saying that the recommendations are more or less laid out as guidelines? Yes, I do understand you well in French, but with your permission, I will answer in English, if I may. Yes?
We had in mind that these were recommendations that we thought it would be good to adopt in order to allow for the safe unfolding of MDSUMC, MAID MDSUMC. One question is exactly which body in a federal state is best placed to put these kinds of things into effect, whether it can be done within the criminal code or regulations versus at a provincial legislative level, or in fact with professional bodies or medical regulators. This is one question, but I think we anticipated that the structure itself put in place.
En quelque part,
Well, to some extent, the recommendations won't necessarily turn up in the criminal code. We might simply have access for people who have medical disorders to as the sole medical condition, and then the practitioners, those in this medical sector, those who are asked to carry out the assessments, will apply the recommendations in going about evaluating different cases in the consideration they will give to various factors. For example, anyone in a suicidal or state or in crisis would not have access to MAID. This is something that speaks to people, given that very often people in the street will say, well, look, are we going to offering MAID to young people who are depressed? But no, that's not what's at issue here. Considering the overall report, how it's structured, it seems that it must be established that the condition is chronic and that the patient themselves has undertaken a number of therapeutic approaches and perhaps used drug therapy, medication. And this has to have taken place over a certain period of time, perhaps a decade, before you're able to access MAID, before you're eligible, found to be eligible. So many people who will be making requests will be turned down, have them turned down.
A certain number of treatments. Could we talk about a certain number of years of experience? And we realized that it had to be a case-by-case sort of evaluation given the heterogeneity of cases, but you're entirely right. It's not possible to establish the incurability, the irremediability, the fact that suffering cannot be alleviated without having tried quite a few treatments. And so that's what the expert panel says, that the person who is in crisis, who is very early on in their experience, who has had no treatments, it will not be possible to establish that they meet the eligibility criteria.
certains psychiatres ont
There are psychiatrists who say that anything can be treated, that suffering can be treated no matter what the psychological condition or psychiatric disorder. Would this be excessive treatment, though? I'm very sorry. I'm not quite sure what the word acharnement psychiatrique is, the medical exaggeration.
J'aurais peut-être
Perhaps I should have been listening to the interpretation. I'm sorry.
to critique without that training, but I do think that my observation as someone external to it is that hope and a dedication to the recovery of patients is part of the psychiatric self-concept, and so frequently. And so, yes, I think that it's important to believe that all is possible, but there are people who've been through an awful lot of treatment and continue to suffer intolerably. And so this concept of the refractory, intractable condition is out there, and after a certain amount of time, from what I've heard, it becomes more reasonable to predict that that might continue.
And next, we will have Mr. McGregor for 5 minutes. Mr. McGregor.
Yes, thank you so much, Madam Co-Chair. And Professor Chandler, I'd also like to take this opportunity to thank you for appearing before our committee. I guess what I would like to ask you, the theme of my question has to deal with, treatments and a person's capacity to accept those treatments, because the criminal code does make mention of an intolerable condition, suffering which cannot be relieved under conditions that they consider acceptable. And so I was hoping maybe you could inform the committee or just walk us through the existing law, how it interprets this, because we're dealing with hypotheticals here. So what if we had a hypothetical situation where a physician knew of a treatment that might be beneficial to a patient who is suffering from a mental disorder? They have knowledge that that patient has applied for medical assistance in dying. How does the law work through that thorny issue where the patient may feel that the treatment is unacceptable and they have made an application for medical assistance in dying? I think these are some of the hypothetical and thorny issues that many committee members and indeed some of our witnesses have been struggling with. So I'd appreciate any thoughts you could offer on that.
Yes. The crux of the problem is knowing whether the suffering can be alleviated, but there are 3 criteria about this prognostication into the future. One is this incurability, one is the irreversibility of decline, and one is alleviation of suffering under conditions acceptable to the person. The preceding 2 criteria don't refer to conditions acceptable to the person. The third does. So the question then would be, if a clinician's aware of a treatment that they think would be helpful, that on balance is not sort of unreasonable in terms of the burdens versus potential benefits, and so forth, and if a person were refusing it, what would happen? I think the way our panel tried to approach this is by talking about the assessor and the requester coming to a shared understanding. So it would be up to the requester to be able to refuse any treatment they didn't want to accept, obviously. But it might be under those circumstances where there's a reasonable treatment available that the clinician thinks might actually help, to then make it impossible for that clinician to come to the opinion that it is incurable or irreversible. So this is a tricky point, but in our proposed interpretation, and as you say, you asked me, how would the law interpret this? We have made proposals of how this law should be interpreted. Our proposal is that under such circumstances, it may not be possible for the requester to conclude that it is incurable if there's something reasonable that hasn't been tried.
I appreciate that. Thank you very much. And I guess my final question is this. We have this final report of the expert panel on medical assistance in dying for a mental disorder as the sole underlying medical condition. But we, as a joint parliamentary committee, we still have our job to do. And this area is one of the 5 major themes that was tasked to us by both the Senate and the House of Commons. So in that context, in your capacity and with the obvious expertise that you have, what would you ultimately like to see in this committee's report to the federal government in terms of recommendations? What areas do you think parliamentarians still have to address under this particular theme? I mean, you made mention of the fact that mental health funding may be inadequate. I would agree with you, and so would many others. But if you could maybe elaborate on that part, that would be appreciated.
Certainly. I think on the funding and resourcing in general, I would say the social supports and the social support funding is very important as a safeguard. I think also the recommendations we made in relation to both pre and post evaluation of files would be very useful. I think that that's an important safeguard. That's something that's in place in some of the other jurisdictions that have gone ahead. This helps to ensure transparency. It helps to promote public trust. I think that that's very important. This, of course, has to be resourced as well. I think that the resourcing has to be in place for assessors to do a good job of this as well, and to have the time and space to do this job properly. I think that the reporting recommendations that we've put into the report are also essential. I think there will be a tricky balance to strike there in terms of the privacy of the people involved and the level of detail that's being gathered and how much of it is to be made accessible. I think it should be made accessible, again, for transparency and public trust reasons, redacted as much as possible to preserve the privacy of the people involved.
Thank you.
I think that's essential.
Thank you, Professor. We've come to the end of this time, but I'm going to turn it over to my co-chair so we can do questions from senators. Thank you.
Merci, Sénatrice Martin. Nous allons...
Thank you, Madam Senator Martin. And we will move on to questions from the senator, beginning with Honourable Senator Miji. You have 3 minutes, Senator. Thank you, Mr. Co-chair, and thank you, Madam, for being with us. My question is about constitutional rights, essential constitutional rights of persons whose sole underlying medical condition is a mental disorder. What are these rights? And what rights would be at issue if we forbid access to MAID?
The rights that have been invoked in the cases so far are Section 7, the right to life, liberty, and security of the person, and also the right to equality, Section 15. So both of those rights, I think, would be at issue if people are excluded. And Section 15, this would be discrimination on the basis of disability.
Supposons qu'il y aurait
All right, so let's assume that we do forbid access to MAID. Would it then be possible to justify restricted access to these rights?
The way the Charter is set up is that, indeed, one can have an infringement of a right, but of course those infringements can be justified under Section 1 of the Charter as a limitation on a right that's reasonable in a free and democratic society, as the language of Section 1. And so I can think of a potential justification, which might be that it's simply one could take the judgment. We don't have the data to support this, and this is why it's so important to collect data, but one could take the position that it is not possible to safely do the assessments that are required to distinguish between those who satisfy the criteria and those who do not, for example. That might be one justification, but I don't think we have the evidence that would support that argument at this point. We have lots of speculation that that's the case, but we don't have, we have a lot of people saying, actually, we do these kinds of assessment of capacity in very high consequence context with mental disorder already, the refusal of necessary treatment with fatal consequences, and so we can do capacity assessment. We don't exclude people who are vulnerable and marginalized for making decisions that might have fatal consequences. So it becomes really hard to justify the exclusion in this context when it's tolerated in a whole range of others.
Merci. Merci, Monsieur.
Thank you, and thank you, Chair.
On va aller.
Thank you, Senator. We will now cede the floor to Senator Kutcher for 3 minutes.
Senator Meji suggested I could get her extra minute. Is that okay with you, Chair?
I'm sorry, I didn't hear that.
I think Senator Meji suggested I could get her extra minute. Is that
No,
okay with you?
3 minutes.
No. Okay.
We've clarified the rules.
In a brief submission to the Senate Standing Committee on Legal and Constitutional Affairs in February of 2021, Shepard and Jones of McGill addressed the access to MAID, and they wrote, "The expressed exclusion of persons with mental illnesses undermines substantive equality by reinforcing and perpetuating stereotypes about persons with mental illnesses and thus disadvantaging them." So I'd like your thoughts on that statement in terms of charter rights. And then another thought, we talked about treatment being unacceptable to people with a sole mental illness and them choosing not to accept it. Are there instances in other conditions, such as cancer treatment or pain treatment, where people will say, no, I've gone through all these treatments and there may be another treatment possible. Who knows, it may work, it may not work. It may be just experimental and I just do not want to have that. But cancer patients can say they do not want to have that treatment. So I'd like to keep it in context of what else happens in medicine.
May I take your second question first and say, I think that's entirely correct, that a cancer patient is allowed to decide, no, I'm done with treatment. Someone on dialysis is entitled to say, no, I'm done with treatment, if they have mental disorder are included. So someone with, I think that listening to my colleagues who are psychiatrists, if someone is refusing a treatment that has a very good profile in terms of benefits and potential risks, there will be scrutiny to ensure that there's full understanding and so forth, but it still remains that person's, a person can refuse it.
It's just like in the rest of medicine.
Yes.
It's not unique to psychiatric cases.
Yeah. And could I trouble you to just remind me your first question?
Oh, it was whether that statement about substantive equality perpetuates stereotypes and disadvantages people who have a mental illness.
Yeah, I think that's certainly also a view that I'd endorse as well, that if we are excluding people solely on the basis of a certain kind of disability, one has to ask the question why. And so it has to in some way be based on a suspicion that, you know, even if they're capable, maybe they're of diminished capacity. So there's a signaling that perhaps their ability to assess their own circumstances and options is suspect, whereas it wouldn't be for someone with a different kind of disability. And so that does have the potential of fostering stigma about mental disorder, that their views are not to be taken as authentic and as entitled to equal sort of weight and credit as that of others.
In terms of that particular perspective, could it be possible that a physician or a psychiatrist who feels that a person who is completely competent and may make a decision about MAID could be stigmatizing that person, maybe inadvertently, that they're not competent or that they can't be treated like any other Canadian?
It's possible, yeah.
Thank you, Senator Kutcher. Senator Delphond, 3 minutes.
3 minutes, sir. Thank you, Mr. Co-Chair. I see that you are a specialist on law, but also in matters of ethics and policy. My question is about framing these decisions. Some studies, we've heard an example earlier, that from one region to another, one province to another, the standards are not applied equally. Do you feel that this means that we should bring in more regulations, given that not all of this is spelled out in the criminal code? And if so, should this be at the provincial, federal, professional, corporation level? And what should be left to ethics?
but a critical one. So, so I think, I mean, this is sufficiently new to Canada and excites sufficient concern amongst the public that it would be important to try to harmonize to the greatest extent possible the process and the safeguards across the country. In a federal state, that's difficult. I was really reading again what we said about the interpretation of these legal terms in the criminal code, asking myself, could somehow something be put into the code about those interpretations? We define many legal terms. Could we try to define some of those terms more clearly within the criminal code? And that would be helpful, but it would be awfully difficult, especially given the nuance that we've tried to explain in terms of the meaning of incurable, irreversible, and so forth. I don't think it's impossible, but it's a possibility. Short of that, I don't think it's possible to put a lot into the regulations because the current code delegates the power with respect to monitoring. Perhaps a greater delegation could allow for more detail to be put into the regulations under the criminal code. That might be another way. But of course, then you run into the difficulty of the federal government starting to do too much that looks a little too much like healthcare. But you have, in the government of Canada, many of the best Canadian constitutional lawyers who can advise you on just how far you can go in terms of that. So that leaves, where else should it go? If we leave it to provinces, the provinces, may not be consistent. They may take varying approaches. I think that a lot can be done by asking for professional associations, for example, of psychiatrists, of MAID providers, and so forth, to promulgate guidelines, because these offer a very important regulatory effect, even if they're not laws. People who don't abide by what is clearly standard of care expose themselves to malpractice claims and all sorts of things. So there's various ways to impose law without having it in the criminal code. The question is, can you get all of those things properly enacted to apply nationally? I believe there's steps well underway to do that just now with the various, with CAMAP, with others. So I think that is another way to provide the kind of cross-country protection that would be advisable here.
Thank you.
A supplementary question, if I may. Could the witness please send in the amended material that will come into force in January?
Oh, I don't have a copy of it myself, but if one goes to the website of Health Canada, you can see that the regulation which was passed in 2018 for the reporting requirements, it sets out the fields of what must be reported, and it says that there's a new one coming to respond to the change of the law in 2021. And this is a discussion that we had also in the committee about other things that should go into it.
So I won't interrupt. I don't want to interrupt you, but the analyst will provide it to
Okay.
all of the committee members. She has access to it, so thank you. And so we'll go to Senator Martin for 3 minutes.
Thank you, and thank you for being here. You noted that the adequate funding is a necessary safeguard for MAID, MD, SUMC, and for both social supports and for assessors. So for clarity, does that mean that MAID should not be available to someone who has not been able to access treatment due to a lack of funding? I ask this because we've heard at this committee that there are people on 5-year long waiting lists for specialized treatment. So funding is a key issue, but what do we do in such case? So if that's not the case, how is funding a safeguard? And would we require a change in legislation in order to to offer MAID to those who are waiting for treatment? There's a lot of complexities.
I think I would distinguish here between access to treatment and access to social supports such as housing and income support and things like that, because if a person has not already undergone extensive treatment, so necessarily has had access to a lot of treatment already, it won't be possible to conclude that their condition is incurable, their decline is irreversible, and so forth. So it's this wait for treatment, I think itself forecloses people from access to MAID because they won't have had that track record of experience and treatment to demonstrate that it didn't work. I think my comments about funding were more directed to the section of Track 2, which refers to exploring the available community supports. And we recommended those community supports should be, the language in the law should be interpreted to include things like housing, income support, and so forth. And it's those kinds of things that I was speaking to in terms of ensuring that reasonable provision is made for those. Understanding that in some cases that might help to alleviate suffering, and in others it might not.
In terms of funding for assessors, are you concerned that the complexity surrounding sole mental illness might lead to inconsistencies and perhaps even MAID being misapplied depending on who the assessor is? Like, how can we ensure that the inconsistencies are not there case by case?
Mm-hmm. My expectation is that there will be a relatively small group of people in this practice area who are going to be speaking with each other and comparing notes and developing best practices. And these are kinds of things that we recommended should be done, certainly, to ensure that the professional development of all the people working in this area. In a way, the likelihood of this being a relatively small number of people involved has a downside in the sense of access. It might be very hard for people to get assessment for MAID in this context, but it also does mean that it's a small group who will be able to professionally develop and compare notes, and in so doing, address concerns about inconsistency.
You said it will take time, so I'm curious about the looming March 2023 deadline, or this time when it will be available. So, are you concerned about the time frame? It's a big country.
It is coming quite quickly, it's true. I come back to what I've heard from people practicing in this area, which is that they're already doing assessments in the context of Track 2, and that the many kinds of considerations that we're discussing here are shared with all Track 2 assessments. So they have had a certain number of months of developing Track 2 processes. And they're already assessing capacity in the context of mental disorder, not just on Track 2, but on Track 1. So this is not starting from nothing, shall we say. There is a certain amount of experience that has been developed already.
Thank you. Thank you, Professor Chandler. I'm going to turn it back to my co-chair.
Actually, and we're going to go back to Mr. Barrett for 3 minutes.
Well, thanks very much, Madam Co-Chair, Professor Chandler. So you had mentioned in our first lightning round there that that you recommended a safeguard with respect to data collection and sharing between clinicians and assessors. Why is that important?
Sorry, is data sharing between?
Yeah, so you had mentioned that one of your recommendations was that that should someone be shopping for an assessment after having been declined, that information would be shared, or a requirement would be that information is shared across assessors.
Mm-hmm. I think that a person's history of requests for MAID could be relevant to a subsequent request, and also the reasoning for a refusal would be relevant to a subsequent assessment. I think there's always a bit of a trick here that someone could have applied the criteria too stringently and turned down someone who ought to be eligible. So it can kind of go both ways. But I think that it's part of the whole picture, and it would help a subsequent assessor to see the kinds of considerations that were before someone who did a prior assessment.
Sorry, please continue, but that's not in place now, correct?
I think it depends on the jurisdiction, the way in which medical records are kept and shared. And it depends on the legislation in place for the privacy of personal health information, which is at the provincial level, might define circles of care in specific ways. So I don't think I could speak for all of Canada. But what we said was that an assessor should be entitled to explore with a requester a range of collateral information, which might include talking to family members if they have a good faith, bona fide reason to think it might be relevant and helpful, and also to speak with prior treatment teams. A person can refuse, but the assessor should be able to ask, and if they feel that there's information there that they don't have access to that is pertinent to their assessment, then again they may be unable to reach an assessment of eligibility.
How much time do I have left? Okay, well, I would just say that, we've been conducting a study at the Standing Committee on Health with respect to our healthcare system across Canada, and you said it depends if this information is being shared based on the, the state of each province. So I would say based on what we've heard from the healthcare community across this country, it's being shared poorly, various states of poorly in each province. And there are some best practices that could be applied, but we don't have any kind of pan-Canadian data sharing, or even within regions of our country that sharing of that information is not happening. So, thanks.
I have 3 minutes for Monsieur Arsenault.
Thank you, Madam Co-Chair, and thank you, Professor Chandler, for being here, and thank you for your answers. Respond in English as you wish. So the May 2022 expert report says that each of the 19 recommendations, according to the experts, could be satisfied without any further safeguards being applied or added to the criminal code, even requests for MAID, DM, SUMC. Do you agree with this?
As long as the various safeguards that we recommended are put in place at the level at which they can be put in place, I would say I think so.
Thank you. Je vais demeurer dans le domaine juridique.
So I'll stick to the legal field, given this is your domain of expertise. Have you had a chance to analyze and compare what takes place in the Netherlands, in Belgium, in Luxembourg, for example? Are there safeguards for people having solely a cognitive disorder, for example, or mental disorder, have safeguards that we don't have or that we might consider?
We have done some looking at what's done in the other jurisdictions. It's taking me back to the days of the CCA report in 2018, where we looked at this in a fair amount of detail and also looked at this in this report as well. I think some of the concepts that we have here were borrowed from those other jurisdictions, such as the idea that in addition to capacity, we would want a request to be well considered, for example, suggesting that there's something in addition to capacity that's required, something that is sufficiently stable, that is not fluctuating too much over time. Concepts like this. Also, this idea of well considered, we suggested, should mean the person shouldn't be able to just sort of reply, yes, I understand the information here, but should be genuinely open to the possibility that a given treatment might actually help them. So these are sort of ideas that we've taken from looking at the way things are done in these other jurisdictions. In addition, the Netherlands has, I believe it's the Netherlands, has a committee which looks ex post at and analyzes the cases and provides reports and practice recommendations. These are things we looked at as well as useful that we could adopt here. So, yes.
Thank you. Still, with regard to legal matters, recommendation number 12 tells us that it is possible that the evaluation team, patient evaluation team, would ask for further information, extra information, even being able to check in with members of their family, for example. So in cases of MAID for mental conditions solely, is there a line that we should not cross? One that would protect confidentiality, the private life of the patient, patient's privacy in MAID processes and in the regime. What do you think the red line should be? Because this seems to suggest that one might refuse or exclude a person who would refuse to allow access to personal material, private material.
There can be cases where it would not be appropriate to go into a person's prior history. There may be risky. There may be difficult relationships with family members where a person might be put at risk. So I think there's certainly going to be cases where there will be a line.
Thank you. We'll next have the real lightning round. Mr. McGregor for 2 minutes, followed by Monsieur Thériault. So, Mr. McGregor, you have 2 minutes.
Madam Co-Chair, I believe the block might be in front of me.
It says you first. I think they've switched the order on the second round, so you can begin 2 minutes, and then Mr. Thériault will do 2.
Okay, I'll be very quick.
Okay.
Professor Chandler, I think we've reached the point in the committee hearing where most of the good questions have been asked and answered. So maybe I'll just use this opportunity to thank you for appearing and maybe invite you to expand on anything you feel you needed a little bit more time to explain.
Let me think. I did have some in mind, and now I've forgotten what they are. I think perhaps rather than take your time, I will see if I can recall them and come back to you in a moment. I can't think of them right now. I'm sorry.
Monsieur, would you like Monsieur Thériault to ask his then, Mr. McGregor?
Sure.
I'm fine, Madam Chair. If you want to go
Yes.
to Monsieur
So Monsieur
Thériault, and
Thériault.
then maybe, yeah.
Yes.
Oui, merci.
Yes, thank you. Earlier, I was saying that the recommendations in the report played a guideline role. If you consider each of the recommendations, you will see the verb shall, must, verbs of that nature. This could solve a number of problems. But taking recommendation 10, given the resistance, there is resistance even among psychiatric experts to the application of MAID. We see in Quebec the association says we should go ahead, but some psychiatrists have testified to say the contrary, which has made it such that Quebec has decided not to go ahead with MAID for people with mental disorders. So we see here that a psychiatrist, a separate psychiatrist, an independent psychiatrist should also assess the situation. Is this doable? Is this a realistic guideline given the resources that are available, especially out in the regions far from the main city centers? Should this guideline be a little more flexible, a little more leeway involved here? And if so, would this make the evaluation less legitimate?
That we struggled with a fair bit, recognizing that the numbers of people available to do assessments would be restricted, and certainly in small locations. We thought about the possibility, which expanded during COVID, of virtual telemedicine assessments as well. I think the problem that you're raising is that every safeguard has a flip side to it. It increases the difficulty of access. It increases safety while posing a barrier at the same time. There's a kind of an inevitable pairing of those things. And so this has to be weighed in terms of, is the additional safety to be achieved justified in light of the additional burdens it imposes? I think that a number of my colleagues felt it was quite important to have an independent psychiatrist to make sure there was a second view on things independent of the type of relationship or other views that might accumulate in the treatment relationship. I think we also thought it was very important to have independent external assessors for people in particular circumstances that would raise the risk of coercion, such as people institutionalized or imprisoned, for example. So I think there are some circumstances where that independent assessment will be incredibly important, essential even. But I don't think I can say any more than that, except that I think you're right. It will increase the difficulty of access.
Thank you very much. We've come to the end of this first panel, and you have taken all of our questions. So thank you very much for being here. And we will, yes, Mr. Anand.
Madam Co-Chair, if we're finished with the witnesses, I have a housekeeping matter. It'll
Okay.
take 30 seconds.
Yes, so thank you very much, Professor. Yes, and Mr. Ananda Sangari.
I would like to bring forward a motion. It says that the clerk of the committee be authorized to grant access to the committee's digital binder to the offices of the whips of each recognized party. It's a routine motion that's passed a number of committees.
Nodding head, so any discussion? Okay, carried. And we will do. Is our next witness ready? Or would you just? We'll suspend for a few minutes to move into our second panel. Thank you very much, Professor. through the joint chairs. When speaking, please speak slowly and clearly. This goes for all of us. Interpretation in this video conference will work like in an in-person committee meeting. You have the choice at the bottom of your screen of either Floor, English, or French. And when you are not speaking, please keep your microphone on mute. So with that, I'd like to welcome our witness for panel 2, who is also here to discuss MAID when a mental disorder is the sole underlying medical condition. So as an individual, we have Dr. Donna Stewart, Professor, University of Toronto, Senior Scientist, Toronto General Hospital Research Institute, Centre for Mental Health. And we will first hear from our witness, Dr. Stewart, for 5 minutes. So Dr. Stewart, go ahead.
Good evening, and thank you for asking to present today. I should mention that I practiced as a family doctor in Northern Ontario before qualifying as a psychiatrist nearly 50 years ago. In 2014, I became a member of the Order of Canada. I'm also a member of the Canadian Psychiatric Association Working Group on MAID for Mental Illness, the Canadian Association of MAID Assessors and Providers, and the University of Toronto Centre for Bioethics. As mentioned, I'm a senior scientist at Toronto General Research Institute, where I conduct research, including research on MAID. I've assessed over 300 MAID applications. I presented to the Senate Committee on MAID in February 2021. My opinions are informed by my affiliations and experience, but I speak to you today in my personal capacity. As a member of the expert panel on MAID and mental illness, I endorse all 19 recommendations, but I'd like to highlight now a few specific ones based on my personal experience in practice. The recommendations I do not comment on are equally important, but my time today is limited. Expert panel recommendation number 1 about collaboration between authorities. It's essential that federal, provincial, and territorial governments work to facilitate collaboration between physician and nurse regulatory bodies in the development practice of standards for MAID. I understand that substantial government and regulator work on MAID for mental illness is currently underway. The 2 sections of the MAID CAMAP curriculum have been written, reviewed, and are currently being revised. And I know that other professional organizations are offering MAID education in various formats. As pointed out, the looming March 2023 deadline is a very powerful motivator. With respect to recommendations 2 and 3, establishing incurability and irreversibility, clearly MAID assessors must consider the severity and duration of illness, treatment attempts, outcomes, and other evidence-based treatments that may improve the patient's condition, while weighing their likely benefits and the burden. This will involve conditions lasting for many years with many multiple attempted interventions. It's my strong opinion that this determination should be a shared one between the psychiatrist in the case of a mental disorder and the patient, and not only the patient's decision. This is clearly specified in the Netherlands Standards of Practice, where physician-assisted death for mental conditions has been available for almost 20 years, and where in 2020, 95% of physician-assisted death requests for a psychiatric disorder were rejected. In fact, completed cases with respect only to mental disorders comprised only 1.3% of all physician-assisted deaths in the Netherlands. A clinical example I can give you is a patient who insisted that only treatments based on natural plant products could be used, and I accordingly felt he did not meet the MAID criteria. With respect to recommendation 4 related to suffering, while enduring an intolerable suffering is subjective and determined by the patient, it is also important that the MAID assessor or provider agrees from a realistic perspective. For example, I assessed a middle-aged woman with mild osteoarthritis who stated their suffering was intolerable because she was raised in the tropics and was nearly always cold in Canada, which aggravated her suffering. Clearly, I did not feel this met the criteria. Recommendations 6 and 7 means to relieve the suffering, clearly multiple safeguards should always be seriously considered, including medical, psychological, and social supports. I recently assessed a cancer patient who was also very depressed. Antidepressant medication and referral to palliative care resulted in her withdrawing her MAID request. With respect to recommendations 10, 11, and 12, relating to independent assessment with an expert, involvement with other healthcare professionals and significant others, in the cases of MAID, SUMC, this should be a psychiatrist, in my opinion, independent of the treatment team to avoid bias. With respect to recommendation 16 on prospective oversight, again, this is vital in my opinion for many Track 2 cases, many of which have comorbid mental disorders which have been poorly treated. This process is not to make judgments of eligibility, but rather to ensure that the assessments are in compliance with the legal and professional standards. This should not result in lengthy delays, but should be an added safeguard by improving quality, safety, and improving timely practice feedback to support patients and practitioners. Recommendation 19 relating to research. As a senior scientist, I believe that regular, targeted, investigation-initiated research on questions relating to MAID should be funded. Research in the Netherlands has informed revisions to their physician-assisted death safeguards and have been very important. In closing, I want to emphasize the fulsome discussions of all recommendations and their salient related issues were conducted during the many, many hours that the expert panel, its subgroups, and individuals met. Various interconnected safeguard mechanisms were available to us and for your consideration. These include legislated safeguards, professional standards, guidelines, and education, each of which plays a unique, interrelated, and essential role. Thank you so much, and I look forward to your questions.
Dr. Stewart, and we'll begin with 5 minutes, starting with Madame Vien.
Merci beaucoup, Madame.
Thank you very much, Madam Co-Chairs. Dr. Stewart, welcome, and thank you for having joined us this evening. Thank you for your testimony. My first question, would you say that the current safeguards are sufficient? Do you feel that we have everything we need to avoid errors?
System is foolproof, but I would say that it's very important that the various provincial, territorial, and regulatory bodies cooperate to make sure that these are firmly established in the standards of practice. If that doesn't happen, then I think legislative safeguards would be needed. But I recognize the cumbersomeness of that, and I think that I certainly hope that standards of practice and guidance and education can deal with many of these issues.
Do you maintain that, and this is a question that we asked another specialist a little earlier, all about 2023 being the time when this will come into force. Is this too soon? Do we have enough time between then and now to really plan our approach, our regimes, such that it be the best possible?
You raise a very important question. My reply to that is that that deadline is a very important motivator. And I think that the speed at which these things are being determined has picked up. Most of us work during the summer, but not everyone worked during the summer. And I think that, hopefully between now and the next few months, some of these things will be put in place. As I mentioned, I know some of the curriculum is currently being circulated and revised. Certainly there are meetings going on, and I would hope that things can be put in place. I don't know for sure. I certainly hope so, and I trust that that will happen.
Madame Stewart.
Dr. Stewart, you mentioned earlier that you denied MAID to some persons who have requested it of you. I understood that correctly, I'm sure. Do you know what became of them? What is the rest of the story. What happened after you turned down their requests for a maid service? What happened to them?
I think that's a very important issue. And what I say to people is, we have discussed your case very carefully. I've thought about this very carefully. I can see that you're trying to deal with this situation, which is incredibly difficult. I honestly don't feel at this time that we can proceed by approving MAID for you. That does not mean it will never be approved, but I think you need to spend more time around the following issues, and I would then detail the things that I thought needed to be addressed. I think it's very important that these people do not feel rejected, because many of them are very ill and suffering in various ways. But I think in a kindly but firm way, assessors need to be clear that in their own conscience and their own mind, that what they're approving is correct.
Dernière petite question.
One final question, Dr. Stewart. You know that Quebec, which is a very progressive province, and I was a member of the government in Quebec when the first legislation was adopted. We know that we have decided not to go ahead with MAID when a mental disorder is the sole underlying medical condition in Quebec. Is this an error, do you think, on Quebec's part?
Well, I would agree with you that Quebec is usually very progressive and has led the way in many aspects of this. I think that you were overly cautious in this regard. And I know that many Quebec physicians feel the same as I do about this, that it was too cautious, but time will tell.
Merci.
Thank you.
30 seconds.
30 secondes. Ah, mais merci.
30 seconds left. Well then, thank you very much, Dr. Stewart. We'll see if we have any other time, and I can share my time with my colleagues who surely have other questions. Thank you again.
Thank you. We actually have our second panelist, as you can see. And so, colleagues, if it's okay, I will invite Madame Doris Provencher, Director General, to give her 5-minute remarks. And then we will go to our second questioner, Dr. Fry. So, Madame Provencher.
Merci.
Thank you and good evening. I'm sorry I turned up late. I had a bit of a technical issue connecting. I wish to begin by acknowledging and thanking the co-chairs, the Honourable Yona Martin and the Honourable Marc Garneau, and all members of the Special Joint Committee on Medical Assistance in Dying for inviting the Association des groupes d'intervention en défense des droits en santé mentale du Québec, a Quebec advocacy group for the rights of people living with mental conditions, to appear and share its thoughts on permitting medical assistance in dying when a mental disorder is the sole underlying medical condition. Allow me to say that our association does not use the terms mental illness or even mental disorder. We prefer to speak of people living with a mental health condition. So that's how I will refer to them. Our association was founded in 1990 with a mission to fight for the recognition and the use of rights of people who've experienced or who live with a mental health problem. We have developed unique expertise in this field. We critically examine mental health practices and support their renewal. Amplifying the voice of people who live with a mental health problem is at the heart of our approach. It's essential to us. Medical assistance in dying in cases of mental health conditions. Well, our association has been discussing this for people living with mental health conditions since the Superior Court of Quebec handed down its Truchon-Gladue decision in September 2019, and the Quebec Minister of Health and Social Services announced in January 2020 that as of March 12th of that year, MAID would become accessible for people living with mental health conditions. The pandemic halted exchanges and consultation on this topic, and I think that you too were affected by the pandemic, so can fully understand this. However, in the fall of 2020, we did launch consultations with our member groups, the vast majority of which are made up of people living with mental health conditions. We felt it essential that those directly affected by these decisions be the first to share their opinions. We have not, as yet, been able to meet with and discuss this sensitive issue with all our members. It's a matter of uncertainty for many. Many have questions about it. Some member groups, however, have been able to consult with their own memberships. It is their reflections that we have showcased in our brief, an English title of which might be Listening to Hear, Giving Voice to People with Mental Health Conditions, Nothing About Us Without Us. In August 2021, we submitted our brief to Quebec MNA sitting on the Special Commission on the Quebec Palliative Care Act, la loi concernant les soins de fin de vie, and we have also submitted it to you. Our brief highlights 3 themes. 1. A lack of awareness of MAID practices. People, secondly, were asking for help to live with dignity. They needed hope. And third, people with mental health problems wish to be consulted and involved in decisions about MAID for people with mental health conditions. Our association doesn't have an official position on this issue, given that we haven't been able to really hold formal meetings and discuss this in depth. However, we have been leaders in denouncing abusive and discriminatory practices for over 30 years. Since the Truchon-Gladue ruling, we have vocally denounced the double standard that treats physical health problems as serious problems, while the suffering of people with mental health conditions goes unnoticed. Prejudice and paternalistic attitudes about mental health conditions lead people to believe that MAID for a medical condition requests cannot be accessed with or even made with full knowledge of the situation or circumstances. Once you're diagnosed with a psychiatric condition, you lose all credibility. Consider the fear expressed by many people consulted that if they applied for MAID, they would be rehospitalized because they would be considered dangerous to themselves and others. Who's better placed than the person living with persistent suffering to judge whether that suffering is tolerable or not? Death with dignity can be a legitimate choice. Accepting such choices is a matter of respect for the people who make them. We believe that individuals have the right to choose in matters of their own life, all the more so when their choice is intimately linked to their very human dignity. 5 minutes is short. I will be pleased to answer your questions. And perhaps we can look into the details of this complex matter in doing so. Thank you, Madame Provencher.
Dr. Fry, you have 5 minutes.
Thank you very much, Madam Chair and co-chairs. I'm so thank you for coming to present to us this afternoon. I really wanted to focus on something that has been a recurring theme throughout this whole question on mental illness being a sole condition, sole underlying condition. I think inherent in this, from everything I have heard, are 2 very important things that I took away from the discussions from everyone else who's talked to us. One of them is that this has to be an individual case-by-case basis. One cannot set blanket laws and blanket decisions for people. And in fact, the whole Supreme Court decision on this issue said clearly that this had to be a case-by-case basis, because we all know, and I happen to be a physician, in that when you deal with a patient with illness A, even physical illnesses, let's just look at physical illnesses for a moment. 50 people with the same physical illness are not going to be treated or not going to respond to treatment in the same manner. So we have to understand the nature of the individual and when we're making these decisions. And I've also, the second piece that I took away from this is that there seems to be a huge level of discrimination against people who have mental illness as a sole underlying condition. The idea that people with mental illnesses do not have compos mentis, or the ability to make decisions or to decide what is intolerable suffering for them, and working in the case with a physician, would be able to come up with a decision that is reasonable for them. And I think that, again, I'm back to making blanket. And we keep talking about blanket decisions. Should we make a generic decision about this or that? I'd like to know your position on that situation. Should we make blanket decisions, legislative or otherwise? Or should we deal with this on an individual case-by-case basis? And should we try not to discriminate between mental illness and physical illness? So I'd like Dr. Stewart to answer first, and then perhaps Ms. Provencher would be able to answer. Dr. Stewart.
Senator Fry, I completely agree with you. These do need to be looked at on a case-by-case decision. And I think that the AB decision in the Ontario Superior Court, made it clear that, in fact, this was not a matter for the courts. This was a matter for physicians to think about and make decisions about based on the entire situation the patient finds themselves in.
Thank you. Ms. Provencher?
Well, yes. It's a case-by-case situation, isn't it? Case-by-case decision, given how different situations can be. About discrimination, I would like to see to it that people with mental health conditions who are making requests for medical aid in dying, that they be treated the same way that someone making a request with another underlying condition be given, much as end-of-life criteria which appear in legislation. It's a case-by-case matter. What I do fear, what I always fear, is discrimination and prejudice. There's a lot of prejudice that people with mental conditions face, even within the health care system, of course. Yes, case-by-case decisions, but people must be taken at their word. We must believe people. I'm not sure how you get that into legislation, but that's what counts.
Madam Chair, how long do I have left?
You have 1 minute and 15 seconds.
All right, I will try to get a succinct answer. You were all very succinct. What I wanted to ask is, a lot of people have been concerned that people with suicidal ideation may decide they want MAID. And I have heard the answers from physicians and psychiatrists who say, but that's a decision that the physician and the psychiatrist who understands their case can make a decision between whether a person only has suicidal ideation or whether that person is indeed suffering intolerably and has tried all methods that they wish to try. And I want to use the word wish to try. So, Dr. Stewart.
Yes, every day psychiatrists make decisions about suicidal patients. You see them in the emergency department, in the community, and in the hospital. This is part of a psychiatrist's role, is to sort out suicidality for a well-considered request for MAID after somebody has suffered for many years, tried many treatments, and has carefully thought this out and feels that this is best for them, and they meet the criteria.
Thank you very much. Madame Provencher.
Well, yes, the issue of suicidal ideation. But look, what I understand of MAID is that I will not necessarily be accepted just because I've made a request. There are many stages, many eligibility criteria. As others say, this decision should be based on the entire history of the person. I think that someone with suicidal ideation who truly wants to put an end to their life will do that in any case. So we need to listen to them and work with them.
Next, Monsieur Thériault for 5 minutes.
Thank you very much.
Merci. Merci, Madame la...
Thank you, Madam Co-Chair. My first question will be for Dr. Stewart. In your testimony to the Senate Committee about C7, Bill C7, you were mentioning safeguards, and there are safeguards in the expert panel report. So do you feel that the expert panel report and their recommendations given that they are guidelines of a sort, do ensure that there are extra safeguards such that we do not need to legislate safeguards, because these safeguards from the expert panel would really frame the regime for practitioners.
I think I mentioned in my report that there are various mechanisms available to consider. We would hope that practice standards, guidance, education would be enough. But, there are people who feel that there need to be specific additions to the legislation. I do not personally feel that, but I think it's a valid consideration that you need to make.
Je me préoccupe de la...
I'm concerned about how easy it will be to get this done. You say March 2023 is a good motivator. That's a very noble perspective, very noble point of view, and thank you for sharing it. But there are a number of issues. The resistance of the medical corporations, psychiatric milieus. Will we always be able to find people willing to act as assessors and providers? I was also listening to you on future oversight. Is it realistic to think that we'll have independent assessment of independent experts? That would mean that in real time, all this would have to come together and work. So tell me what you think of that, this independent assessments. How would that actually work?
I think, as Professor Chandler said earlier, there will probably be a small group of people who talk with each other, experts who talk with each other about some of these issues. I think that certainly there is some anxiety about doing this, particularly until we know what the standards are going to be. I think that, the prospect of oversight should not take a long time to put in place. For example, in Ontario, we have the Ontario Capacity and Review Committee that meets within 7 days to consider treatment of mentally ill people. A similar mechanism could be put in place for people who meet MAID criteria. And as others have said, I think that's going to be a tiny number of people. Based on the Dutch experience, 95% of these people get rejected, would never come before such a committee. They comprise about 1% of all physician-assisted deaths. We're not talking about large numbers of people that reach this level, and I think they deserve a sober second thought through prospective oversight.
But who? Who would make up such committees, such oversight committees? And should all cases be considered by them? Mightn't we wind up, as we did in the past with therapeutic abortion committees, where it's really impossible to sit across the country with to ensure equal access across the entire country without, creating another obstacle which would actually get in the way of access to MAID.
Well, I'm old enough that I well remember those abortion committees, having served on a few of them. I would hope that we don't replicate that, but I think as an early step to make sure that these things are proceeding smoothly and that people are not getting physician-assisted deaths who should not be getting them. I think some oversight at the beginning is very reassuring, both to patients and to practitioners. I know that the Canadian Psychiatric Association strongly endorsed this and felt that they would really welcome such oversight. So you ask who should be on such a committee. Off the top of my head, I think clearly we should have one or more psychiatrists. We should have one or two good legal experts. We probably should have one or two bioethicists, and perhaps we should have a patient representative. So I think that, we need to think very carefully about who best would serve on such a committee. It should be small, it should be nimble, and it should be able to meet quickly.
Excusez-moi.
I'm sorry to interrupt you, but that's already quite a few people. And my concern about how easy it would be to go ahead with this, I'm a little more worried than I was even before, because getting so many people together who would then be called on to make a second decision about decisions made by professionals who've already made decisions. I find this worrisome. So I think we should continue exploring the definition of this prospective oversight group, because often in ethics it's retrospective oversight. So why would you need a committee that would become the very committee that would be making the decisions if the practitioners, the assessors and psychiatrists have already actually done their job correctly? If I may.
Sorry,
categories.
Sorry, we're well over the time, but thank you very much. We'll go to Mr. McGregor for 5 minutes.
Thank you so much, Madam Co-Chair, and I want to thank both of our witnesses for helping guide our committee through this study. Ms. Provencher, I'd like to start with you. Just, you were talking about the advocacy work that your organization does. And our previous witness was talking about, the Charter of Rights and Freedoms and how it applies. Section 7, that everyone has the right to, life, liberty, and security of the person, but also Section 15, that everyone has the right to be equal under the law. You know more than anyone around this committee table that there is a high degree of stigma that exists in our society when we are talking about people who suffer from mental health conditions, as you like to say. And your organization is not taking a position one way or another, but maybe you can put your answer in the context of those charter rights and the case-by-case basis, like how important it is to try and combat that stigma and to understand that people who are living with mental health conditions do have that agency, do have that capacity. Is there anything more you want to add to this conversation so that not only this committee understands the issue, but also the wider Canadian public who are listening to this?
Madame Provencher?
Je sais pas si je peux. Oui, merci.
Yes, thank you. I'm not sure if I can give you a fulsome answer, but as you say, in the Canadian and Quebec Charter of Rights and Freedoms, there are, of course, the sections you've mentioned, and the matter of discrimination. And the Truchon-Gladue ruling truly is based on the charter protections that you have brought up. Having a mental health condition doesn't remove my ability to consent to something. I am still able to consent. So people with mental health conditions who are living with these conditions are people who are able to make decisions, fully capable of doing so. And these are serious decisions, making a decision to apply for medical aid in dying. And it's a long-term work that we have undertaken to advocate for their rights. We want to ensure that people living with mental health conditions speak up and are heard. I've been working with them closely for 30 years now, and I can absolutely assure you that these people are just like you and me. They're just like anyone else. These are people with emotions, histories, with difficulties. Who doesn't have difficulties? So the way we look at them, just because they have a mental health condition, it's discriminatory, because we consider them to be incapable, unlike others. So how are we going to change that? We've been working at it for 30 years, and we care about this. So putting people at the same level as any other citizen of Canada under the law, I think that would be a good step forward.
Really appreciate that. Dr. Stewart, in the limited time I have, I'd like to ask you maybe on the same theme. Just, if you have an answer on the stigma part on a similar question. I guess the other thing too is why this issue of capacity keeps on bringing up is because every province has something. Like my home province, right? We have the Mental Health Act. It does allow for people to be involuntarily held if a physician feels there's a medical reason for doing so. So these are kind of the thorny issues we're trying to assess when it comes to that issue of capacity and consent. But if you can add anything more to this answer, I'd appreciate it.
Yes, I think that I agree with Madame Grandfrechet. In general, mental patients have equal capacity, but a few don't. And of those who don't, they're the ones who end up as voluntary patients.
Yeah, and then finally, you know the work that has been done by the expert panel. Do you have any final recommendations that you would like to see us as parliamentarians put in our report to the federal government? What areas more does the federal government need to address?
Very briefly, Doctor.
Yeah, I think I have addressed that in my presentation. I think all of it, but the ones I specifically mentioned are especially important.
Okay, appreciate that. Thank you.
Okay, thank you very much. And that concludes the round of questions from the MPs. I'll turn this over to the co-chair for senators' questions.
Thank you, Senator Martin. Nous irons maintenant aux questions des sénateurs.
And we will now turn to the senators for questions, 3 minutes each, beginning with Honourable Senator Migy. Thank you, co-chair, and thank you to the witnesses. My first question will be for Dr. Stewart. I am thinking of your work on practice standards, and I wonder how we can ensure that medical health practitioners who will be assessing or evaluating requests for MAID are well trained to do so. And I have a secondary question for that as well. I'll put it right away. What are the main challenges that these assessors and providers will face for people people with medical conditions become eligible?
Educational curricula currently being developed by CAMAP, and certainly the Canadian Psychiatric Association has been very involved with its working group around trying to develop some standards for practice. I think that, all of these things need to proceed. I think the various regulatory colleges for both physicians and nurse practitioners need to weigh in on this. So I think that work is well underway. It needs to keep moving along at a rapid pace to meet the deadlines. You asked about what are the main concerns. The main concerns are the uncertainty that currently exists about what the standards are going to be. And the sooner this can be firmed up, the more reassured the practitioners will be. I think that I conducted some research with 131 Canadian MAID assessors and providers from across Canada, now published in the Journal of Palliative Care. And it was very clear that one of their main concerns, their main stressors, was wanting to know what the standards are going to be so that they felt that they were operating within the safety of clear standards rather than having to sort of make decisions that aren't clearly defined at the present time. So I would urge you to include the expert panel recommendations very clearly and to endorse some of the CAMAP educational materials and the college regulatory requirements as they appear.
Thank you very much for your answer. Do I have more time? 8 seconds only. I'm sorry. Very good then. I do have a question for you, Dr. Stewart. In all your research and discussions about standards, has there been any discussion of support personnel, support for the professionals who will actually be providing MAID? I have heard among my colleagues that some found this difficult, who would provide the service, but then would have a variety of feelings about it afterwards and have difficulty managing those feelings. Have you heard something like this? Have you thought of any resources to support the providers?
They exist. CAMAP, the Canadian Association of MAID Assessors and Providers, provides a forum for providers. And it's a very active forum where people talk about their difficulties, their feelings. People share suggestions, and it's very powerful. I should point out in our research, we found that although there were stressors to this practice, there were many more personal rewards where people felt this was very important work, it was very compassionate work, and many felt it was some of the most important professional work they do. So it's a combination of both stressors and protective factors, and there are lots of protective factors. But the CAMAP forum offers a big support.
Thank you. Merci. Nous irons maintenant au Sénat.
Thank you. I now recognize Senator Kutcher.
Very much, Chair, and thank you to the witnesses for being here. First question is to Ms. Provencher. Do you think that denying access to a MAID assessment for a competent person with a mental health condition who meets all other criteria for that assessment could be a form of stigma against people who have a mental health condition?
Ben, écoutez, la question posée de cette...
Well, a question put as you have, I can only answer in the positive. Yes, it would be discrimination if the person meets all eligibility criteria. But if I may, I'm not sure if I may, if I have time, but I would like to say something about training. Please involve people who are living with a mental health condition as you draw up your training. This would be essential. Ensure that the professionals who are being trained hear directly from people living with these conditions. That's my recommendation, my personal recommendation to someone who works with them. I'm sorry. I'm not sure should have taken a sideline like that. But yes, it would be discrimination, because what would the refusal be based on? Simply because the person is suffering from a mental disorder? If so, yes, it's a stigma and it's discrimination.
Your comments about training and the role of people with lived experience. For our other Dr. Stewart, I'm going to share a quote with you from the Globe and Mail of an individual saying, and I would like you to respond to the statement. And the statement is this, quote, "Any attempt at identifying who would have access to MAID will make large numbers of mistakes, and people who would have experienced improvements in their symptoms and no longer wish to die will die by MAID." What do you think of that statement?
Well, I think that statement echoes one that was also written, perhaps by the same person or groups of people, that said we're trying to fill our graveyards with mentally ill people through MAID. Those kinds of statements are extremely unhelpful, hyperbolic, and, that kind of misinformation fuels the public anxiety and, to some extent, the professional anxiety about this. I think we need to be very clear and very factual in these kinds of things. And I wish that people would stop writing and printing this kind of misinformation and fear-mongering.
Thank you. I'm sorry, Senator. We'll go to Senator Delphon.
Merci.
Thank you. Thank you to our witnesses. My question is for Ms. Provencher. I read with great interest the brief that you brought to the Quebec National Assembly about the position and of your group. I have those recommendations before me here, and one of your conclusions was, please do not exclude people who are suffering from mental illness. Do not exclude them from access to MAID, because this is a discrimination based on stigma. In your brief, you recommend standards and education and social interventions and careful safeguards. At page 40, you speak of criteria and safeguards. Do you think, now that you have looked at the special committee report, that these current safeguards suffice? Well, all right. The ones that are laid out here, it's really people who are specifying these criteria, eligibility criteria, and safeguards as well. Yes, they are of use, but once again, where are the real people with lived experience? It's, yes, of course, they want safeguards, and Ms. Stewart mentioned this as well. Dr. Stewart, the issues and misrepresentation that we see sometimes in the newspapers. But even those with mental illness are misinformed. They say, oh, they want to kill us. They want to get rid of us. So there's a lot of education to do, a lot of awareness raising that this will all have to undertake. Your association was concerned about when this would come into force, feeling that that the guidelines need to be taught to all professionals involved in MAID before this comes into force. Look, we're not too worried about this coming into force. It's not about being for or against MAID. Our message is, are people who are living with a mental health condition able to make a request for MAID? That's what we're deeply concerned about. Will they be allowed, treated on the same footing as other Canadians? There was a commission in Quebec about the end-of-life care legislation, and we were very disappointed by the Commission's work and its results, because they basically slammed the door on any discussion, any possibility of people living with a mental health condition be able to enter into the discussion about MAID. So that's what's unfortunate. Yes, there's a lot of work to be done. Yes, we need a regime. We need to frame this. We need safeguards. We need guidelines. But please leave space for real human beings. And if there are people who are excluded, who are found by definition not to be eligible, well, they'll go to court, and you'll wind up having to deal with this in any case. Sorry. Thank you.
The last questions from Senator Martin.
Thank you, Mr. Co-Chair. And my questions, plural, are for Dr. Stewart. I'll just ask them all together and you can answer. So we've heard a lot of people say at this committee that MAID is not suicide. It is clearly important to differentiate MAID from suicide. This is really at the heart of this issue. In the spring, psychiatrists told this committee that MAID for sole mental disorder blurs the line between suicide prevention and suicide assistance. Given the uncertainty around determining irremediability in the case of sole mental illness, how can this line be defined? How do we distinguish between intolerable suffering and suicidality? And what additional safeguards do you think are necessary to ensure that the MAID regime does not provide assisted suicide?
Thank you, Senator. You know, it is true that there are a few psychiatrists who express exactly those views. They are certainly not the majority. And certainly the working group of the Canadian Psychiatric Association did not express that. Psychiatrists make this determination every day of their practice around suicidality. As I said earlier, in community, emergency departments, and hospitals, it's an essential part of being a psychiatrist to assess suicidal risk. I submit that a request for MAID, carefully considered, that meets the safeguards, is not the same as suicide.
Est-ce que je peux répondre?
May I answer as well?
Madame Provencher, if you have the fact that the MAID for sole mental disorders requires very specific safeguards, did you want to add anything else that you've said regarding specific safeguards that you would recommend?
C'est-à-dire que oui.
Well, yes. safeguards are needed, much as for accessing MAID for a sole medical condition. Some have said it would take 2 psychiatrists, others say 3. Yeah, you need safeguards. But I would like to go back, with your permission, to the discussion about suicide. I think it would be very important for professionals to listen to people and hear them, that they overcome their prejudices that we all have, to really hear people. And as the Association of Psychiatrists of Quebec has said, it depends on a person's background, their history, the type of suffering that they're living with and have lived with. All these things are part of a personal story. It's not a diagnosis. It's really the person's lived experience that has to be at the center of the decision-making. Professionals have to take this into consideration, have to really address things in a very broad way when they analyze requests. Really hearing people, listen to them, listen to what that person actually has to say to you over and beyond a diagnosis. That's what we wish for. Thank you very much. And this brings our session to a close. I would like to thank you, witnesses, Madame Provencher, and
to answer our questions and for your opening statements. You're very important witnesses in this very important analysis that we are trying to do as committee members, and we very much appreciate your candor and your very straight shooting with respect to all of the questions that were asked this evening. Thank you very much. And with that, this panel is, or this committee is adjourned. Merci.